Hello, my name is Brett Bendistis, and this is a Blue Book video citation on the IRAC writing form entitled "The IRAC writing form is supposed to look weird." Now, the reason why this is titled the way that it is that commonly the reason people have problems with the IRAC writing form is it looks strange. It's a weird way to write. I've taught for a couple years now, and I found that the most difficult student I've ever had to teach or reach was someone who transitioned from 8th grade English class to a paralegal career. Right? And as we were sort of developing and passing things back and forth, she looked like me like I was crazy. I looked like her like she was crazy because it just doesn't really match up. It's not the same form of writing. The one nice thing I have often found is that I hated writing in high school and I hated writing in college, but I really like writing in the IRAC form because it is almost mathematical. It's a very simple form where as long as you hit the forms, everything goes together. Right? So what we're going to do is really delve into everything. And I only have one rule when it comes to this, is please do not send your writing to anyone else to get it proofread, right? I have an aunt who's very good at proofreading, but I cannot give her my writing because she doesn't look at it the same way that I do, that your teacher will, that your employer will. So make sure when you're putting IRAC things together, you're valuing your own intuition and that these 4 things are all put together, right? So the 4 issues of IRAC are issue, rule, analysis, and conclusion, right? Conclusion's kind of easy, so we're not going to go into that much. But let's start with issue, right? The issue is what is the problem that needs to be answered? Okay? In regard to an issue, what we want is something that develops facts and law. Okay? We're going to have a problem here that deals with someone who is dealing drugs on their property, let's say. And their neighbor calls the police and says, hey, my neighbor's selling drugs. And the police say, anything you can do to help us, that would be great, even if it includes going to the house. So the neighbor goes to the house, gets the drugs, no warrant is ever received, and our client is arrested, and we have to figure out what the answer is, okay? The issue there could be something as easy as, can Brian be arrested? The issue can be as simple as something as, can the neighbor, search Brian's property? But neither of them are good legal issues. What you want to do is really incorporate something that's both facts and law. I've often found that the best form is, does this law apply when these facts apply? Or do these facts apply when this law applies? And that's really a good approach to it. That's a starting point. The other big point that I think you need to jump into is creating a thesis statement that's included within the issue. Like, I should read your issue statement and know what the rest of it is going to be. Therefore, do not write your issue statement first. It is the first statement you have, but do not, under any circumstances, write that first. Right? What you first want to write is your rule statement. Your rule statement is essentially what is the law that governs the situation. And I think there are 3 big key parts to any rule statement. All right. In regard to these elements, I just also want to point out that every single sentence in your rule statement has to cite to some authority. It has to. There's no choice in the matter. It should not incorporate any of the facts, and it should just be a broad statement of law. Okay? The way that you relate the rule statement, which is the law, and the application statement, which is the facts, is the rule statement blazes the path, the application walks the path, right? So the elements you want with the rule statement is 1, what is a broad statement of the law? And where's the starting point? Here we're starting with the 4th Amendment. That's absolutely where everything has to go. There needs to be warrants, so on and so forth. After that, you get into what are the major elements of the law and when does the law definitely not apply. So start with the way of, this is the starting point of everything, right? Start at the top, work your way down. After that, you want to do practical ways to prove the law, which is what is the standard of proof, what is the burden, and how does one side win over another? To me, this is the part that is missing from almost all bad legal writing, where you're not referencing the fact that there's a test that has to be proven, that there is some kind of development, right? Because it's never just the top statement of law, you know? Like, I often think that there's this idea of what's reasonable, right? Like, there's always this thing of like whether it's reasonable or not. Now, I think it was perfectly reasonable to eat a ton of ice cream cake at my wife's birthday yesterday, but maybe someone else would say that that's too much for a 35-year-old man, right? Reasonableness has to be determined by a certain test. Your sense of reasonableness will never bring you before the court where you're arguing what you think is reasonable compared to what anybody else does. So get the standard for any type of vague term. Right? The last thing I think is, again, what distinguishes bad legal writing from even just okay legal writing, which is if you need to describe a case, if you need to reference the facts and you need to include something, only include it at the very end. Okay? That's the deal we're going to have with each other. There seems to me this propensity that because case law is hard to understand, your rule statements become this idea where you're just describing case law. But the description of cases is never going to be that applicable. It's never going to be that relevant. Because if you say something is going to be related, I'm going to say, no, it's not. It's one of the things about being a lawyer, which I'm sure, in addition to eating a lot of ice cream cake, my wife maybe isn't totally stoked about. But the key thing is just getting the rules of law. Because if you have a very detailed rule of law, it doesn't matter what the facts are as much. It still can be relevant. But the key thing here is the reason you're using law is not to fill up time. It's not to tell a story. The only reason is to explain to a reader what is the way your sentences really get pulled together. Right? And then after the rule, you have the application, which is how the facts apply to the law, right? So going over the hypothetical we had last time, neighbor searches a person's house and it's a problem. So here, our issue: did the police conduct a warrantless search of Brian's property when the police caused Brian's neighbor to trespass into Brian's backyard and conduct a search of a small storage unit? Right? That is, by all means, a run-on sentence. It's not perfect English, right? But it incorporates the law, warrantless search, the causing the neighbor to trespass, which is sort of the incorporation of the agency consideration. And that's sort of where everything gets developed. So again, it doesn't have to be perfect English, and your answer doesn't have to be the same way that mine is. The only thing that's really important here is making sure that you're including an entire picture of the way that the law is developed. Let's look at the law here real quick too. And I want to point out that if you can create a rule statement, you can write anything. So I tend to think the first thing you should be writing is the rule statement and do everything else second. So here, the Fourth Amendment protects citizens from unreasonable searches and seizures by police, which violate the defendant's right to privacy. That's the starting point. This applies against actions by the police, and the Fourth Amendment will also apply to a search done by a third party who is coerced by police to search a defendant's property. Next element, right? So it's sort of the starting point and then the more pertinent thing. This is a big thing. When determining what constitutes coercion, the court will apply an objective test. Right? I mean, that's just how it gets proven. So the key thing there is that element of objectiveness helps you even really understand how to put everything together. Because if you don't know how the test works, your application doesn't have the same depth and persuasiveness that it really should. So here, Brian argues his neighbor was an agent of police that violated his right to privacy by searching a storage unit in his backyard. Although the neighbor was not a police officer, the court will look to see if the neighbor was objectively coerced by police to search the property. The court will find that the neighbor was not coerced because police did not threaten the neighbor and only made a vague statement about assisting in the investigation. This is not like in Riley, where the defendant was threatened with police action because the neighbor had no consequences if he refused to conduct the search. Right? So we're using a case to help compare everything. We're not developing any new sections here. It's a really thing where they kind of stand side by side, right? So you have all the law here, all the facts here. And then finally, very, very easily as a tidy end up, you put your conclusion, right? So one of the key things I also want to note here is there's a level of symmetry, right? So the symmetry here is that you've got the law that starts and the application follows it. Again, one blazes a path, the other one creates it. Let's go through one more really quickly, where you've got someone who has regulations by a city that are depriving the person from being able to rent their property, right? And they're arguing that it's under the takings clause of the Constitution. So the city of Media, which is the party, did they violate the taking clause by issuing a ruling that would prevent Brian from receiving economic value from his property? Again, facts and law. And it also sort of develops later on when we go through here. Now, my head is cutting off the rule statement a little bit, but I just want to point out a few things here that might be helpful. Again, the Fifth Amendment of the Constitution prohibits the government from taking citizen property without just compensation. The takings clause applies to both when the government takes physical control of the property and also when the government passes a rule that denies a citizen all economic value. We're developing the test a little bit. You're going to note the fact that the rest of these sentences get into the practicality, but I want to get into the last sentence. In Greenwood, the court held that a generally applicable zoning violation was not a taking, and in Grasso, the court held that a denial of a building plans under a broad regulatory scheme was not a taking. We're developing law, and we're including a section here that talks about how the law gets put forth. So when we go back to the application section here, it follows the same structure. We're introducing the sentences, we're developing how the law is, and at the end, we're only using the law to make a comparison that was from there before. So we're trying not so much to just tell a story and just kind of assume itself. It's got to be there. All right. The only key, last thing I want to point out with the application is the fact that this is not retelling the story, right? So when we go back to our old Fourth Amendment section, This isn't one of those things where we're saying, by the way, the neighbor was there. By the way, the police said this. Your application should always have the word because after a lot of sections, or there should be qualifying sections of why those facts are important. One of the tricks I think people get into is not feeling comfortable enough just making the statement, just saying the way that you feel about things. But in regarding these IRACs and these assignments, you really just want to kind of make sure you're putting an analysis through and you're explaining something. One of the nice things about being a lawyer is if you're right about something, be a jerk about it, right? Like if you think something is right because of 10 things, say all 10 things. I once had a trial where somebody didn't pay rent for a full year, and I went through this long song and dance where I said, did you pay for January? Did you pay for February? Did you pay for March? Did you pay for April? And went through every month. Now, in addition to laboring the point out, it proved how many months weren't being paid rent, and that's how your writing should be. If you feel like there's 10 reasons why you're right, go over all 10 reasons why you're right and add some substance to it. Because one of the things about IRACing is I feel like people where it's not developed enough is one, not adding the practical elements and not including the application. You can't just assume that you're right because you say you're right. You've actually got to prove it, which is one of the sad things about being a lawyer. That is this lecture for today. Thank you guys again very much for watching. If you're interested in this video, please check out my other on YouTube. Also check out my podcast, which is the Citizen's Guide to the Supreme Court, which is on iTunes, Google Play, Stitcher, or the internet, right? It just covers current Supreme Court cases. Thank you guys very much. And again, I hope you guys learned something today.